case briefs, and so much more. LSData's got what you're looking for.
In 2002, the United States Court of Appeals for the Ninth Circuit heard the case Barden v. City of Sacramento, which centered on the accessibility of public services and facilities for people with disabilities under the Americans with Disabilities Act, ADA. A group of individuals with mobility and vision disabilities filed a lawsuit against the City of Sacramento, accusing the city of violating the ADA and the Rehabilitation Act. The plaintiffs claimed that the city failed to install curb ramps in newly constructed or altered sidewalks and did not maintain existing sidewalks for accessibility. The court determined that public sidewalks were a service, program, or activity of the city and therefore subject to program accessibility regulations. Although the parties agreed on installing curb ramps, they did not reach a consensus on removing other barriers. The court's decision was then certified for interlocutory appeal and granted. The majority opinion concluded that the public sidewalks in Sacramento fall under Title II of the ADA, which means they must adhere to program accessibility regulations. The district court's order was reversed, and the case was sent back for further proceedings. The court ultimately ruled that the City of Sacramento's public sidewalks were subject to the regulations outlined in both the ADA and the Rehabilitation Act. This decision supported the plaintiffs' claims that the city had violated these two crucial pieces of legislation aimed at protecting the rights of individuals with disabilities.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.